EU to charge Apple under Digital Markets Act, impose a fine of up to $50 million per day. Back in March 2024, the European Commission announced that it started an investigation relating to Apple's new fee structure for alternative app stores. Namely, the fact that Apple charges a core technology fee for developers who want to steer users to offers outside of its App Store. There's also an additional 3% that goes to Apple if a developer uses its payment processor. The imposing of such fees onto developers will be found in breach of the EU's Digital Markets Act, DMA, according to a new report from the Financial Times. This would be the first time a tech company would be charged based on the DMA, which started having effects earlier this year. An announcement of the charges is allegedly expected in the coming weeks, according to people familiar with the matter. Apple is facing a fine of up to 5% of its global daily turnover per day for non-compliance. That's around $50 million per day. But it won't necessarily get to that. Things are a bit more complicated, since the company could still take actions to correct its practices to the satisfaction of the EC after it announces its preliminary findings in the near future. The final text of the Digital Markets Act, DMA. Article 6, obligations for gatekeepers susceptible of being further specified under Article 8. The gatekeeper shall comply with all obligations set out in this article with respect to each of its core platform services listed in the designation decision pursuant to Article 3(9). The gatekeeper shall not use, in competition with business users, any data that is not publicly available that is generated or provided by those business users in the context of their use of the relevant core platform services or of the services provided together with, or in support of, the relevant core platform services, including data generated or provided by the customers of those business users. The data that is not publicly available shall include any aggregated and non-aggregated data generated by business users that can be inferred from, or collected through, the commercial activities of business users or their customers, including click, search, view and voice data, on the relevant core platform services or on services provided together with, or in support of, the relevant core platform services of the gatekeeper. The gatekeeper shall allow and technically enable end users to easily uninstall any software applications on the operating system of the gatekeeper, without prejudice to the possibility for that gatekeeper to restrict such uninstallation in relation to software applications that are essential for the functioning of the operating system or of the device, and which cannot technically be offered on a standalone basis by third parties. The gatekeeper shall allow and technically enable end users to easily change default settings on the operating system, virtual assistant and web browser of the gatekeeper that direct or steer end users to products or services provided by the gatekeeper. That includes prompting end users, at the moment of the end user's first use of an online search engine, virtual assistant or web browser of the gatekeeper listed in the designation decision pursuant to Article 3(9), to choose, from a list of the main available service providers, the online search engine, virtual assistant or web browser to which the operating system of the gatekeeper directs or steers users by default, and the online search engine to which the virtual assistant and the web browser of the gatekeeper directs or steers users by default. The gatekeeper shall allow and technically enable the installation and effective use of third-party software applications or software application stores using, or interoperating with, its operating system and allow those software applications or software application stores to be accessed by means other than the relevant core platform services of that gatekeeper. The gatekeeper shall, where applicable, not prevent the downloaded third-party software applications or software application stores from prompting end users to decide whether they want to set that downloaded software application or software application store as their default. The gatekeeper shall technically enable end users who decide to set that downloaded software application or software application store as their default to carry out that change easily. Furthermore, the gatekeeper shall not be prevented from applying, to the extent that they are strictly necessary and proportionate, measures and settings other than default settings, enabling end users to effectively protect security in relation to third-party software applications or software application stores, provided that such measures and settings other than default settings are duly justified by the gatekeeper. The gatekeeper shall not treat more favorably, in ranking and related indexing and crawling, services and products offered by the gatekeeper itself than similar services or products of a third party. The gatekeeper shall apply transparent, fair and non-discriminatory conditions to such ranking. The gatekeeper shall not restrict technically or otherwise the ability of end users to switch between, and subscribe to, different software applications and services that are accessed using the core platform services of the gatekeeper, including as regards the choice of Internet access services for end users. The gatekeeper shall allow providers of services and providers of hardware, free of charge, effective interoperability with, and access for the purposes of interoperability to, the same hardware and software features accessed or controlled via the operating system or virtual assistant listed in the designation decision pursuant to Article 3(9), as are available to services or hardware provided by the gatekeeper. Furthermore, the gatekeeper shall allow business users and alternative providers of services provided together with, or in support of, core platform services, free of charge, effective interoperability with, and access for the purposes of interoperability to, the same operating system, hardware or software features, regardless of whether those features are part of the operating system, as are available to, or used by, that gatekeeper when providing such services. The gatekeeper shall not be prevented from taking strictly necessary and proportionate measures to ensure that interoperability does not compromise the integrity of the operating system, virtual assistant, hardware or software features provided by the gatekeeper, provided that such measures are duly justified by the gatekeeper. The gatekeeper shall provide advertisers and publishers, as well as third parties authorized by advertisers and publishers, upon their request and free of charge, with access to the performance measuring tools of the gatekeeper and the data necessary for advertisers and publishers to carry out their own independent verification of the advertisement's inventory, including aggregated and non-aggregated data. Such data shall be provided in a manner that enables advertisers and publishers to run their own verification and measurement tools to assess the performance of the core platform services provided for by the gatekeepers. The gatekeeper shall provide end users and third parties authorized by an end user, at their request and free of charge, with effective portability of data provided by the end user or generated through the activity of the end user in the context of the use of the relevant core platform service, including by providing, free of charge, tools to facilitate the effective exercise of such data portability, and including by the provision of continuous and real-time access to such data. The gatekeeper shall provide business users and third parties authorized by a business user, at their request, free of charge, with effective, high-quality, continuous and real-time access to, and use of, aggregated and non-aggregated data, including personal data, that is provided for or generated in the context of the use of the relevant core platform services or services provided together with, or in support of, the relevant core platform services by those business users and the end users. Engaging with the products or services provided by those business users. With regard to personal data, the gatekeeper shall provide for such access to, and use of, personal data only where the data are directly connected with the use effectuated by the end users in respect of the products or services offered by the relevant business user through the relevant core platform service, and when the end users opt in to such sharing by giving their consent. The gatekeeper shall provide to any third party undertaking providing online search engines, at its request, with access on fair, reasonable and non-discriminatory terms to ranking, query, click and view data in relation to free and paid search generated by end users on its online search engines. Any such query, click and view data that constitutes personal data shall be anonymized. The gatekeeper shall apply fair, reasonable, and non-discriminatory general conditions of access for business users to its software application stores, online search engines and online social networking services listed in the designation decision pursuant to Article 3(9). For that purpose, the gatekeeper shall publish general conditions of access, including an alternative dispute settlement mechanism. The Commission shall assess whether the published general conditions of access comply with this paragraph. The gatekeeper shall not have general conditions for terminating the provision of a core platform service that are disproportionate. The gatekeeper shall ensure that the conditions of termination can be exercised without undue difficulty. A few weeks ago, Apple announced the rules that developers have to follow to make their apps available through third-party app stores and even through simple web downloads. However, these rules were very restrictive, and the European Commission thinks they may not comply with the DMA. The Commission has launched investigatory steps relating to Apple's new fee structure for alternative app stores. The Commission writes, Apple's new fee structure and other terms and conditions for alternative app stores and distribution of apps from the web, sideloading, may be defeating the purpose of its obligations under Article 6(4) of the DMA. The fee structure refers to Apple's proposed core technology fee, which will charge developers 50 cents for each first annual install per year for apps that have received over 1 million downloads from third-party app stores. This also includes downloading updates. Obviously, this could be devastating to small developers who find that their app exploded in popularity. Instead of celebrating, they would be worrying about how to pay Apple's fee. And they might have to leave an old app without updates, as it would incur new fees. Apple isn't the only so-called gatekeeper that is in hot water with the Commission, and self-preferencing is usually the issue. For example, Alphabet is under investigation for promoting its services in search results, i.e. ranking Google Shopping, Google Flights, Google Hotels, etc., above competing services from other companies. Additionally, Alphabet's steering rules may be preventing developers from sending users to offers outside of the company's App Store free of charge. Amazon is accused of self-preferencing too. Is Amazon pushing its own branded products above alternatives from competitors? The Commission is looking into it. Meta's new pay or consent model hasn't passed the sniff test either. Last year, Meta introduced paid ad-free tiers for Facebook and Instagram. The Commission is concerned that the binary choice imposed by Meta's pay or consent model may not provide a real alternative in case users do not consent, thereby not achieving the objective of preventing the accumulation of personal data by gatekeepers. Alphabet, Amazon, Apple, ByteDance, Meta, and Microsoft are the 6 gatekeepers that were designated in September 2023 and had to fully comply with the DMA by March 7. The Commission did grant a 6-month extension for Meta to finish work on Facebook Messenger, work that will allow its users to chat with users of other apps. Note that these are preliminary investigations. The European Commission has not conclusively determined whether the gatekeepers do or do not comply with the DMA. But if the answer is not, then the companies may be hit with fines up to 10% of their annual global revenue, rising to up to 20% for repeat offenders. EU Digital Markets Act, DMA, a new regulatory framework aimed at ensuring fair competition and preventing market abuse by large technology companies. To curb anti-competitive practices and promote consumer choice and innovation. Apple's position, first major tech company to be scrutinized under this law. Potential charges relate to Apple's App Store practices, particularly concerning third-party app developers. Specific concerns: App Store commission fees. Apple charges a 30% commission on in-app purchases, which has been criticized as excessive. Restrictions on app distribution. Apple mandates that iOS apps be distributed through the App Store, limiting alternatives and competition. Self-preferencing. Allegations that Apple favors its own apps and services over third-party offerings. Implications. Impact on Apple, possible fines and required changes to business practices. Increased scrutiny on other aspects of its business model. Broader industry impact, sets a precedent for how other big tech companies might be regulated. Encourages more competitive practices and potentially more consumer-friendly policies. Apple's stance, defends its App Store policies as necessary for security and quality control. Argues that its commission fees are standard and support the ecosystem. Developer community, generally supports regulatory intervention to lower fees and increase app distribution options. Regulatory perspective, aims to level the playing field and foster innovation by reducing gatekeeper power. Future outlook. Changes in App Store policies and fee structures. Increased transparency and fairness in how apps are managed and promoted. Ongoing monitoring, continued regulatory oversight to ensure compliance and effectiveness of new measures. Potential for similar actions against other tech giants under the DMA. This situation marks a significant step in the EU's efforts to regulate digital markets and curb the dominance of major tech firms, potentially leading to a more competitive and fair digital economy.